with regard to IT-related laws, we've talked about one big area that is developing, that is AI. I've covered that area with you in a previous session. Now, I want to talk a little bit about computer software because everything we do is a computer software. Most things we do is now most of our lives are spent in front of a device. And these devices run on software. The hardware side is very simple. The hardware side is, in fact, simply that we protect hardware if there is a novel hardware through a patent. You get a patent for the hardware, like if somebody develops a new chip, you can protect it by way of a patent if it's new. Now, I assume Apple, when they develop their M series chips, if you're familiar with Apple, they developed their own series of chips called the M series of chips. When they moved away from Intel, when they did that, I'm sure they got patents for it. So patents is a very straightforward, cut and dry thing. But how are computer softwares? Because now what's more important is the software you run than the hardware you have. The hardware isn't that important, but the software is very important. So now when you run software, we have to ask the question, how are software protected in the eyes of the law? 99% of the countries in the world protect software by way of copyright. Software is protected by way of copyright. Right? So you've learned copyright law already, so I don't need to go into copyright law with you. So it's protected by way of a copyright. Now, there are countries like the United States where you can protect software by way of a patent, but it's very few and far between. Sri Lanka, including most other countries in the world, will protect your software using copyrights. This is provided for, and it's funny because our act in 2003, they foresaw this. In 2003, we had basic running computers, but computers would come to this level, nobody would have thought. But the nice thing is, in Section 6 of the Act, in the Intellectual Property Act, Section 6, they mention that computer softwares will be protected by copyright. What it does is, it leaves the word computer software quite vague and open to interpretation. So even new things, so you imagine 2003, a smartphone had not been developed. The first iPhone had not been developed. So we didn't have software in that way. iPads were not a thing. But the way that act was built, the way they worded it was smart, that they were able to interpret all of that software into this definition, because it kept it quite broad. So that's the advantage of the acts keeping themselves broad. When they keep it broad, they allow more scope. Right? So the Act provides, in Section 5, it defines what a computer software is. A computer means an electronic or similar device having information processing capability. Very simple, very broad. A computer is a electronic or similar device having information processing capability. Very simple. So even a smartphone now can qualify as a computer. No problem. So computer softwares are protected in the eyes of the law using copyright. So what is the threshold for protection of copyright? Does anybody remember? How do you, in order to get protection, what is the threshold? Our artists should know. Roshani? What's the threshold?
Originality?
Yes, 100%. Originality is the threshold. Correct. You simply have to have that the copyright, the work has to be original. If I write a song, it has to be original. It must not be copied from someone. Basically, that's what it means. Copyright. It's an automatic right. Copyright. The right to prevent someone from copying your work.
Correct.
So, in order for your work to be original, it simply must not be copied from somebody else. It has to be from your own imagination that you have created. It can be very similar or identical to somebody else's, provided you have not copied it. Now, this idea of what's the idea? The idea of a teenager who goes to a wizarding school and vanquishes evil is not unique to J.K. Rowling. J.K. Rowling is not the only person who has written those series of books. There are lots of other books. You may have heard of some. One is called The Sorcerer's Apprentice. Sorcerer's Apprentice is another series of books very similar to Harry Potter. The storyline is very similar. But is it violating copyright? No, it isn't. Why? Because Sauda talked about this idea, a dichotomy between idea and expression of idea. What we protect through copyright is the expression of the idea, not the idea itself. Ideas are not protected. Expressions of those ideas are protected. How they are expressed are protected. Right? So similarly, computer softwares also get protection by this same way. So let's talk about an example, right? Everybody here is about my age, or I think, yeah, so I think we will relate to this, right? When smartphones became a thing first, when they started, right? Again, I say that you all will be able to relate to this simply because when I talk about this with young children, they don't have any idea, right? There was a game called Temple Run. How many has played Temple Run? Have you all heard of Temple Run? Played Temple Run?
Heard about
Temple
it,
Run?
but not played.
Okay. So Temple Run, if you haven't, just give it a download on your smart device and just have a look at it one of these days. Temple Run is a very simple game. The phone is held vertically, right? You hold the phone vertically and your character runs, right? Basically on the screen it runs. It just keeps running, perpetually running. Your object is to move left, right, left, right, left, right, and it moves. That's it. That's a very simple game, right? Temple Run. Okay. It was a major hit, massive hit, right? Now, obviously, it is protected by copyright because it was an original creation. It was a new creation. Then there was a whole slew of games that did the same thing, right? There was one called Odds Run. There was one called Subway Surfer. There were so many games that did the same gameplay, which is the character moves left and right with your phone, right? And it's running. That's it. It's a very simple game. It's a very addictive game. I remember when I first got a smartphone, I was addicted on because it keeps you going. The game just makes you run, right? It's very, very, very interesting game. But there were lots of copies. Now, were those copies of the software? Were they infringing upon the rights of Temple Run? That is a question that we have to answer. And the answer would be no. Why? Because they copied the idea. They didn't copy the expression of that idea. The way that it's been expressed, no. The look and feel wasn't the same. The graphics weren't the same. The characters didn't look the same. But the gameplay, the idea of the gameplay was the same. Now, there's a similar question mark with regard to word processing softwares you can make. No? Take word processing software. Take Microsoft Word. Take Google Docs. Take Apple Pages. All of them does the same thing. No? What do? They give you a blank sheet of paper and the ability for you to type. Now, if copyright law prevented anybody else from creating anything similar to a word processing software, then Microsoft would be the only people who would be able to create these things. But no. The idea is the same. Very few new ideas are there on the internet. Right? If you look at software, most of them do the same thing, very similar. I don't know what, depending on what kind of apps you use on your phone, right? Now recently I was downloading some apps for me to use track my fitness, right? Running, gym, what to track it. I downloaded about 5 apps. And I went into them. They do the same thing. The way they do it is identical. But the graphics look different. The way the look and feel looks different. So what does it mean? They're not copying on the other person, because the whole law on computer software protection pivots on this logic of idea, expression of idea. Ideas are not protected. Expressions of idea are protected. Do you follow that?
We do.
Expressions of idea are protected. Right? So we have to make sure we understand that logic. So your software must be original. It must not be copied from someone else. And what you are getting protection for is only the expression of the work. So this brings us then to what aspects of your computer software are protected. In computer software, there are two aspects that we have to talk about: literal elements and non-literal elements. There are literal elements and non-literal elements. What are the literal elements of a computer software? Anybody who's involved in computer software development, I'm not an expert in this kind of field at all. But literal elements is the code that you use to write your software. You understand that every computer software that you see, say for example, you are now seeing a screen with squares of people popping up on it. That's what Zoom is, no? Right? That's what the Zoom software looks like. That's what you see, no? But behind that is a lot of code. Code is usually written in binary, 1 and 0, right? Ones and zeros. It's a whole heap of code that is written for you to see this. You will see this interface, but behind that, there is a lot of code that is written. We call it the source code of an app or a software. Source code. Source codes are protected by way of copyright. By literal copyright, just like you protect a book, the lyrics to a song, a poem, you protect those by way of literary copyright. No, basically, the words are protected by copyright. Similarly, this code is protected by copyright as a literary work. The literary elements of the computer software are protected. So there are multiple instances where there were copying of literal copyright. So one case is a case called Ibcus Computers versus Barclays Bank, Barclays Finance. I'll tell you, I'll basically kind of summarize, give you the highlights of that case. Basically, Ibcus, I can't remember the party, one party had a computer engineer working for them who developed a software for them. Okay? The other company wanted a similar software. So rather than invest in the technical knowledge to develop that on your own. Now, if they develop the software on their own, there is no violation. Remember, it's not copying. I told you the requirement is copying, right? If they don't copy and develop their own software, there's no problem. But what did they do? They went and approached this computer engineering company A and said, look, if you want to come and work for us, we'll give you a lot of money. We want you to develop a software just like the one you have developed for Ibcus. This guy said, okay. And before he left the company, he plugged in a pen drive, copied all the source code of that he had written and that he had created, and took it to the other company and used the same source code to develop a software for these guys. Right? They were sued for violation of copyright. And how did the judge catch it? The judge said, look, even the errors, the codes also have, like we have spelling mistakes, codes also have mistakes, right? There are mistakes, errors. That's what we call bugs in software. You know, bugs arise because there are mistakes, errors in the code. The judge said even the errors that were there in company A software is there in company B software. That's why you will be very careful when you copy from somebody else. You must not copy the mistakes also he's making. Because if you copy the mistakes also, then it's obvious plagiarism. Right? How can you have the same spelling error that the other guy who has done the thing has a spelling error? No, you can have a different error. Right? You will be very careful. That's how we catch plagiarism. So when I teach for the LLB, we get flagged up sometimes and say, look, these two papers look identical. Are they plagiarized? So one of the things we look at is, are the mistakes and the errors the same also? So that's a very easy way to know that they've copied. Right? So these are tricks that you must learn not to do. Right? Even, I always say, even if you are cheating, you be smart about how you do it. To not get caught. That's very important. Right? So Ibcus Computer says that literal elements can be protected by copyright. Okay? Now, what about the non-literal elements? Non-literal elements is what you and I see in a software. What do we see in a software? We see what we call a UI, the user interface. The user interface, what we see. We see the icons, the colors that have been used, the placement of the tiles, placement of different aspects. We see any video that has been placed on it. Now, some softwares have videos. There's an opening animation that is played when the software is booted up, right? Then there's a noise of audio that plays. Now, if you think about a game, I don't know if there are any gamers here, right? If you play, let's say, FIFA 2024, right? If you play FIFA 2024, the software, when you boot it up, there is an animation that plays and there's audio that plays. All those are visual, non-literal elements of your software. Then think about Microsoft Word, the drop-down menu. When you click File, what do you have? You have a drop-down. When you click Edit, you have a drop-down. When you have Format, you have a drop-down. How those things are formatted. The fonts that you use, the size of those fonts, how the icons look. All of those are visual elements that you and I see, right, in the software. Can they be protected by copyright is the question. Literal elements can definitely be protected as a copyright. Can non-literal elements be protected? This was asked in a case called Navitaire versus EasyJet. Navitaire versus EasyJet asked this question. Now, in Navitaire versus EasyJet, this is what happened. Navitaire developed a website. This is a booking website. You all use your Agodas, your booking.coms, whatever, to book flights, kayak. You use these softwares to book your flights and your hotels and all that, right?
Correct.
So Navitaire developed a software like that, which was very easy to use. Okay. Now, EasyJet wanted they wanted a very similar software to the Navitaire software. So they hired their own tech consultants and said, look at the Navitaire website, it's a software. We want a software that looks like that. Now, the software engineers for EasyJet did not have access to the source code, not like the earlier case. They didn't have the source code of the Navitaire website or the software. They developed it by themselves. But the objective was what? To mimic the Navitaire software as much as possible. The look and feel to look almost identical. So the question arose, can there be protection granted for the look and feel of your software? Can the look and feel of your software be protected in addition to the source code? The source code is protected, but unfortunately here the source code is not copied. So can the look and feel be protected? In a lengthy judgment, the judge recognizes all the non-literal elements in a software and says what can be protected. I suggest that you go through and look at that judgment to see what aspects can be protected, what aspects can't be protected. Right? He says things like structure of the program, sequence of organization, screen display, user interface, look and feel, audio visual may contain the software may attract a copyright. Right? So the audio visual elements will attract copyright. The look and feel, how you have laid out your software will attract a copyright. Right? The icons might attract a copyright. The lay down of your interface, how the drop-down menu is structured might attract a copyright. They can all attract a copyright. But at the same time, he says so many things can't attract copyright. So we understand now, thanks to these judgments, that a computer software is protected as a copyright and what can be protected in a computer software as a copyright. You can protect literal elements of the computer software, that is the source code can be protected, and you can protect the non-literal elements of a software, but of course it's limited. You can't just say the entire UI is protected. Certain items is not protected. Let's say, for example, if I create a new search engine, right, and I put the search bar in the middle and say search, it's very similar to Google search engine, no? Google search engine is also just search, Google search, and feeling lucky. Those are the two buttons at the bottom. That's all, no? right? Those two buttons are there, and then the search bar is there. Now, if I want to create a search engine, I will also have to have a search bar and a click button. Those two things I'll also have to have. Just because my one has that doesn't mean that it will be violating somebody's copyright. So the codes are limited. They won't allow you to get protection for the entire user interface, because if that is the case, there will only be one software in each. It will create a monopoly. Remember, we don't like monopolies. We want to have competition. More competition there is, the better it is. Right? Now that is why the United States government is currently suing Apple. Did you all know about that? The United States government is currently suing Apple for creating anti-competitive behavior, that they are anti-competitive. Because what they do is they lock you into an ecosystem. Once they lock into the ecosystem, very difficult to get out. Your Apple device will only work with Apple functions, right? Your text messages don't work on Android phones, right? AirDrop doesn't work on other devices. So they lock you into that. So therefore, there's anti-competitive case that is going on. So we don't like that. So judges are very careful to say not the entire user interface is protected. Only certain aspects of it are protected. Clear? Right. So who owns computer softwares? Who owns the copyright? The copyright is owned by the guy who creates the computer software. That's pretty straightforward. Unless, of course, you are working for somebody when you develop it. If you're working for an employer, so I would have talked about it, the employer owns the copyright. If a copyright is created in the course of your employment, who owns the copyright? The employer. You don't own it. But of course, if you go home and in your free time you develop a software, then you will own that copyright. But if you develop it at work or using the office laptop or something like that, then the employer can say, look, we own the computer software. Created. And of course, if it's a commissioned work is where I commission you. I pay you some money and ask you to develop a computer software for me. Then I am the owner of the copyright because I have commissioned that work to you. So I may have covered all of this in copyright. I don't know if you had the time because there were time constraints. But ownership of a copyright belongs to the creator unless it is created in the course of employment or it is a commissioned work. Clear? Thoughts on this? Any concerns?
No.
Anything?
Clear, Mahela, for me.
Yeah. Anybody else? Any concerns? Because it's quite a technical area to explain. So I've tried to simplify it as much as possible, but it is quite technical. And unfortunately, you won't find this material in Vikram Surya's book. His book was written before the time of all of this software and all that, so you might not find that kind of material in the book. But research on this is easy. The internet is full of this kind of research. So you can look this up. So look this up if you're interested in learning more. I won't be giving a question on this topic, but if you're interested in learning a little bit more about it, you can do that. There's enough and more material available. If there are no questions, can I move on to the Electronic Transactions Act?
Yeah.
Okay. So there are two little pieces of legislation I want to talk about before I come to the big one, which is the Data Protection Act. Electronic Transactions Act. The Electronic Transactions Act is passed in 2006, a very small piece of legislation. What it does is that it simply provides that electronic versions of documents are valid evidence, are valid, has the same validity as a physical piece of document or physical document, right? So Section 3 provides for it. Section 3 says all electronic documents must be recognized as valid. All electronic documents must be recognized as valid. So your text messages, your WhatsApp messages, your emails, your Slack messages are all recognized as electronic documents and are considered valid. So it's valid evidence. If you want to adduce it in court, you can do so. The email is a valid piece of documentation. I come to that. Section 4 then says, when there's a requirement for section 3 is okay?
Yeah.
Yeah. When section 4 says, when there is a requirement for something to be in writing, it shall be satisfied if it's in an electronic form. Now we have this requirement sometimes that you have a written form, you have a written requirement. Now I get this sometimes dialogue says when I want to do something with my, Wi-Fi or my TV connection or something like that. They say, sir, we need a written document, a written confirmation. We want you to give you a written confirmation. You may have had this experience. So this act says that requirement is satisfied if I send them an email. It doesn't have to be a physical document. But of course, Sri Lanka, we are very reluctant to adapt this. Right? We constantly still ask for physical documents for people to come and reduce their physical documents. It's very complicated, right? Even scanned versions, they are reluctant to accept in Sri Lanka. But of course, the Act provides, since 2006, we have said electronic versions of it is sufficient. If there's a requirement for writing, that's satisfied by doing it in electronic form. Section 5 says that the requirement for an original is satisfied if the document is in electronic form. Right? Say, for example, you have a warranty card that you get now. You get warranty cards, no? When you get warranty cards, one of the most obvious things that we do is we lose our warranty card. If we lose it, no. I, of course, have been guilty of this. I constantly lose my warranty cards. Now, as of late, what do? I take a picture of the warranty card. And I save it on my Google Drive under warranty. I have a folder called warranties and I keep all that warranties in my Google Drive. So that what it means is now because of this, a shop card refused to do my repair on the basis you don't have the original document.
Original.
If I have the scanned version of it, that is satisfactory. Right? So similar thing is said in section 6. The retention of information is satisfied if that information is stored in electronic format. If they say you have to retain documentary proof of something, if you store it electronically, it should be fine. Right? Now, the next section that's important is electronic signatures are recognized under the Act. The Act recognizes electronic signature. So when there is a requirement for a signature to be placed, you can put an e-signature. So this e-signature can be a verified e-signature or an unverified e-signature. That's not a problem. There is no requirement for it to be a verified e-signature. If you want it to be verified, you can get it verified. You can get a verified e-signature. Right? But you don't have to. So I use an e-signature which is not verified. But I use it to sign everything. Right? That's fine. And now with your smartphones and your tablet, you use that to sign. Right? Now you sign documents and the PDF, you open the PDF, go to signature, and you just put your signature with your finger. It's e-signature. It's not verified, but it's valid. Right? So, but if you do want to go the route of verifying it, Sri Lanka's authority on this is Sri Lanka CERT, Sri Lanka Computer Emergency Readiness Team, right? And they have a certification provider that they have appointed. That is Lanka Clear Private Limited. They go by this name of Lanka Sign. So if you want to, this is the domestic authority to verify your signature. So if you want to get a verified signature for Sri Lanka, you can use Lanka Sign. But of course, now most people don't use Lanka Sign. What we use is things like DocuSign. In your offices, do you all use DocuSign? Is that something that is used? Do you all use DocuSign to sign documents or no?
No. That
you all use physical documents,
sometimes we are using scan signature. We are putting that is valid.
That's okay. That's fine.
That's
If
fine.
you are okay with it, that's okay. You scan your signature in and you put that in place. Yeah, that's okay. People do that also. That is what you do. So, but that's not a wet signature, that's a dry signature because it's still an
Yes.
electronic form. Yeah, it's not a wet signature. Wet signature means you have to use a pen to say a sign. So,
Yeah.
some countries still require for it to be a wet signature, but now most places don't. Very rarely will they require wet signature to be placed, but some few things now, even Sri Lanka, land matters still need a wet signature. You need to do land. That's the impossible task of transferring your land. You have to physically present in front of your notary and sign. We have so those are exceptions to this law, but generally speaking, for businesses, for contract purposes. Now I work for a company. We get signatures on a daily basis, hundreds of signatures. My team gets all these signatures electronically. They email it to the guy, he puts his signature and sends it, we send it to the other guy. Now, but most people use DocuSign. DocuSign is almost a universally accepted standard for signatures.
DocuSign, na?
DocuSign, yeah. It's a company. So DocuSign is a system, system where you put in your contract, and DocuSign will provide you the places for you to sign. So it's almost verified by DocuSign. Right? But in Sri Lanka, the verification authority, guys, is Lanka Sign. Now, I'll read a little bit of Section 7 just to make this clear to you. In terms of Section 7, it says the method of verification is reliable as appropriate for the purpose of which the electronic communication was generated. So, meaning there is no requirement for there to be verification if the parties are happy. Contract law, no, mostly. If the parties are happy with the signature being you putting you email the document, I put my signature and email it back to you and you sign it. If we are happy with that, then that's good enough. It doesn't have to be a verified signature. But of course, there is a method for verification. If necessary, we can get it. So Section 7, relatively important section. Section 3, 4, 5, and 6 are very important also because they let you know that you can make an argument. I've got into numerous arguments with dialogue and all that, right? About why they need the physical document. Like, it doesn't require, it's not required. But they say sometimes, unfortunately, although these acts are passed, the TRC and all that have not adapted them yet. You know, that's the problem. In Sri Lanka, we have enough laws. We are just not implementing them. That's our problem. Not that we don't need more laws. We just need to implement the laws that we have. Right? If we do it, we have a very good legal system.
And I had a bad experience. I mean, this recent, just before. I was in the share market. So, as you may know, that Expo, they delisted. So, they given a cutoff date to submit that, I forget that name, that form name. I was in Oman. So, what I did, I asked my brother to send it scan, then I sign and I send it to them, the signed copy. And that what the condition was, okay, you send the copy, but before 20th or something, that I need to hand over the signed copy to them. Okay, fine. No. Yeah, I came 13th and 14th morning, around 12 o'clock, I went to them and I gave the documents. They says, no, this is not the one we need the original has to be signed. I said, this is the one. I got it because I was away from the country. I got this scan copy from my brother. The original was in home. No, they need original and another thing, the date was passed. They said that it was in 13th. I said, no one told me. Now finally what happened? I had to, I mean, they said that there are some case going on. Maybe again come into the acting, but we need to wait and see. Now it is finished.
Oh my goodness. Hopefully you're not losing a lot of money.
Not much, but still.
I mean, this is ridiculous, no? This is Sri Lanka. The fact that they are unaware of it, that's the problem. These guys are, the government is the worst. The government departments don't know any of these. That we have these acts, that we can use them. They don't know anything. They want physical, everything has to be physically done. Like, nothing can be done electronically, which is ridiculous. So, I don't know how to say change it.
I mean, even these people even don't understand what is the purpose of having. I mean, I clearly asked if someone in abroad, how he is going to give you the, or he said that you need to get courier and at the help.
Crazy, I know. This is the problem. This Electronic Transactions Act. I bet 99% of you didn't know the electronic transactions existed even. Act existed even. Right?
And
I'm sure you all didn't even know.
Yeah, even I opened that account while I'm in Oman.
Yeah, that's the thing. Yeah.
So you can open the account, but you
But you
can
can't.
withdraw.
Yeah, this is normal, no, Rangaji. Depositing your money and investing your money is easy. No questions asked.
Yeah.
Withdrawing, I cannot, there is a story, but I cannot tell you in front of Mahel and the ladies here. One day I will tell you.
Absolutely. Okay. So, Section 11 is also relatively important in the Act. Section 11 says that electronic contracts are also valid. Contracts generated electronically. So, when you click I accept, and that will become very relevant when we talk about data protection in a minute, right? When you click I accept and you use a software, those electronic contracts are valid as far as the law is concerned. So, Sri Lanka relatively forward thinking. Now, the company that I work for, I oversee the function of about 5 South Asian countries, and all of those countries very recently passed this act. We passed it in 2006. We are ahead of the curve. Now, we are one of the very few countries in the world that in Asia that has a data protection act. We're well ahead of it now. I'm sure when the AI Act is passed, we will pass an AI Act also. So it's good. Our legal system is very competent. It's just a matter of now translating that competency to people, for people to use it. You will now go and tell another person. That person will go and tell another person. That is how this system has to work. We have to buy. We don't spend time explaining the importance of these. No, we only, politicians haggle about other things. Half of the politicians don't know that this act is passed. That's the problem, right? Anyway, I don't want to get into politics because I have no faith in the system, right? And Section 21 and 22 finally say that electronic documents can be provided as evidence in court. So that amends the evidence ordinance in Sri Lanka as well. So basically, if you want to produce an electronic document, you can do so. Just like you can produce a physical document, I can produce emails as physical as evidence. No problem. But of course, someone might challenge saying, is this email actually sent by you? So then you will have to get on the stand and say, yes, this email was actually sent by me. So that proof requirement will still be there, but you can reduce it. Right? Okay, we move on then to the Computer Crimes Act of 2007. I think the only place where we talk about criminal offenses in this program. In this module, we don't generally touch on criminal law. So, and I had a conversation and we decided criminal law is not within the scope of business law, so we don't need to go into it. But this we felt was important to include. The Computer Crimes Act of 2007. Basically, it covers offenses that may be committed using a computer or a smart device. Right? Offenses that may be committed using a computer. So, Section 3 and 4, very simple, starts off very simple. Obtaining unauthorized access into another person's electronic device is an offense. Simply obtaining access, simply taking access to somebody else's device without their permission is an offense as far as the law is concerned. Section 4 says getting unauthorized access to another person's device with the intention of committing a crime. You don't have to commit the crime. Intention of committing the crime is an offense. Right? So that's very, very important to understand. So we take it very lightly, right? We take access to our friend's phone, right? While they are not looking, It's an offense as far as the law is concerned. All right. Section 5. Using a computer to perform a function without authority is an offense. Let's say I get into my office computer and delete all the files before they fire me. I know they're going to fire me. So I get onto my office computer and I delete all the files without their permission. That's an offense under the Computer Crimes Act. Right? It's an offense to delete these files without permission. So very important to understand. So getting unauthorized access to another person's device, unauthorized access to commit a crime, and committing a crime are all offenses as far as the Act is concerned, Section 3, 4, and 5. Section 6 then says, using a computer to do something which threatens national security, national economy, or public order is an offense. National security, national economy, public order. So let's say a hacker hacks into the Colombo Stock Exchange. Now Rangajiva is not very happy with the Colombo Stock Exchange. So Rangajiva decides he's going to hack into the Colombo Stock Exchange, right? He hacks into the Colombo Stock Exchange. He's committing an offense under Section 6, right? Why? It is threatening national economy. Not only that, anything that will affect public order. Now, I don't know if you all saw this. This was hilarious. One day, when the country woke up, some boy had hacked into the Laksala website, right? And he had taken out all the images that were there on the Laksala website, and he had put images of himself draped in all kinds of Laksala clothes, Laksala cloth, and uploaded it on the website. So the website was him draped in all kinds of clothes. So for a few hours, that website was there, and then it was taken down. That's disrupting public order. Some people do it just to prove a point. Now, this one boy recently hacked into the education ministry to show that it's unsecure.
Yeah. And President,
right?
Sorry? Previous president, his what do you call, his web page or something, someone hacked, no?
Yeah, correct. So now any people who are skilled with computers are very skilled with computers. So this act is very important to be there, because if not, committing offences is very possible. So this is the section that they try to also catch you for using the computer. Now we have the, what is that called, the Online Safety Act. I think we have the Online Safety Act now.
Online Safety Bill.
No, not bill. Now it's an act. So when something becomes a bill to an act is when it is passed in Parliament, it becomes an act, Chaminder. So before it passes from Parliament, before it gets the Speaker's signature, it's a bill.
Right.
But the moment it becomes valid law, it becomes an act. So you call it a bill until you call it a bill until it is passed. As soon as it's passed, it's an act. So now it's an act of Parliament, right? So before that, national security was this Section 6 was what you use to punish anyone who would spread disharmony or racial violence against on social media and all that, using a computer to threaten national security. Think about it. You start, now even in England, right? The racial riots in England that happened, I think, a few years ago, were orchestrated through WhatsApp. So using a computer, so phone is a computer, using a computer to commit an act which threatens national security, that's an offense. Right now, this is why now it's going to be interesting, because now all these platforms are moving towards encryption model. Encryption models is to make sure that the messages that you send to another person cannot be tracked. It's when you send it, only the other person who receives it can read it. Nobody else in the middle can. You can't hack into it and see what the messages are. The government can't say, like tapping a phone line, you can't hack it anymore. Even the servers can't see it. So Facebook can't see the messages that you are sending to somebody else. Those messages are encrypted, they say, yeah, right? But now the question will arise whether that is going to be tolerable under when online safety bill, even this, on the basis that it is threatening national security. So it's question mark.
But in the Middle East, very straightforward, Mahela. In the Middle East, like, okay, you will not give us the access. Okay, WhatsApp no more. Now in countries like Saudi Arabia, WhatsApp.
That is the reason.
So that will happen. So the encryption. So it's a compromise, right? It's a data privacy versus national security discussion. So we'll have this conversation when we talk about data protection, right? It's a conversation that there's pros and cons to it, right? You can't ban all these things and say, no, anything that doesn't allow you to track you, we can't allow you access. But then it becomes difficult to maintain also, right? Because you have to understand, in a country like Sri Lanka, the moment you make that decision, you are not getting re-elected. 100%. What's important for these guys is more than anything else, a politician's main goal once you get into power is what? Getting re-elected. This is not just Sri Lanka, this is globally. Any politician, that is why they don't touch sensitive topics, because they don't want to antagonize the majority. They want to get re-elected. So you can do that. You can't do it in, very, very, very strict democracies. It's very difficult to do. In strict democracy, it's very hard to do and get away with it. So you have to find a compromise. So I don't pass judgment on the Online Safety Act because I haven't read on it. Everybody has an opinion, unfortunately, in Sri Lanka. But I still don't. I haven't really studied the act yet. But once I do, I will hopefully have an opinion. But we don't know. There is a necessity for it as well. But at the same time, there are issues of data privacy. Those are questions that arise. Anyway, we'll come to that. Right. Section 7 says tampering with data without authority is a offense. Tampering with data. So hacking into a system to tamper with data is an offense. Illegal interception of data is an offense. Section 8. Illegal interception. So that means there can be legal interception. You have to understand that. When they say illegal interception is illegal, not allowed, legal interception will be allowed. So maybe a court order can be gotten to intercept a certain thing. Now, that's what happens with WhatsApp and all that. WhatsApp is encrypted unless you get a court order.
Yeah.
You get a court order, they will release it. They will decode it for you. Right? So, similarly, illegal interception is not allowed as far as the law is concerned, Section 8. Section 9, we definitely have a break. Can I just finish this couple of sections? Can you give me 5 minutes to give the break? Is that okay? Sorry, somebody messaged on the chat group.
Roshani.
Is that okay? 5 minutes?
Roshani, is that okay with you?
Okay, Roshani is okay. Roshan's okay. Roshani is okay. She just messaged me. Right. All good. Okay. So Section 9 says that dealing with a device that is used to commit an illegal act is an offense. Now, back in the day, DVD players, right, were geo-locked. They were region-specific. I don't know if you all remember back in the day when DVD players started to come into the market. If you bought a DVD player in Asia, it can only play DVDs that were made for the Asian market. They were locked to the region. The reason was because then Universal Studios in America creating DVDs can sell the same DVD of the movie at a different price in America and a different price in Sri Lanka. Because we know they can sell it at a cheaper price in Sri Lanka because the DVD, so somebody can't buy the DVD in Sri Lanka, bring it to America and sell it, use it. Because it will not work in the DVD players in America. That was the reason. They had it region specific. But what happened? Our geniuses in Sri Lanka started jailbreaking DVD players. Right? They used a little device, a little chip was put in, which allowed you to play any DVD. Same thing we did with phones. Back then, phones came locked into a carrier service. Remember, there was a whole business that thrived around unlocking your phone, unlocking phones, right? These are illegal offenses as far as the act is concerned under Section 9. And finally, Section 10 says unauthorized disclosure of information stored electronically is an offense. So WikiLeaks, you all have heard of WikiLeaks?
Yeah, Julian Assange.
Right. What he is doing, well, yeah, what he is doing is an offense under Section 10 as far as Sri Lanka is concerned. Unauthorized disclosure of information stored electronically. He's hacking into a system, taking data illegally and giving it to the world. He's being Robin Hood basically, but that's not allowed. So Section 25 says that if you are violating any of these sections under the Computer Crimes Act 2007, you will be heard you will be committing an offense and you will be punished in the High Court, the criminal High Court of Sri Lanka. So it's not a minor offense, guys. Minor offenses are heard in the magistrate's court. So you are going to be tried alongside the rapists, the murderers, right? It's a severe offense. This. So it's very important to understand what you can and cannot do with a computer device. Especially when you use office computers, you have to understand you are not the owner of that device. You can only do what they allow you to do with that device. If you do anything beyond that, it is committing an offense. Even deleting files. So when I left my previous employer, I told them, look, all the data that I got in the time I was here is in this folder. Make sure you back it up because the next guy will need to use it, right? I'm not going to erase anything and then take it. Right? I erased my personal data that was there, like my HR file that I was maintaining on the laptop. I erased that, but everything else I kept on the laptop. So we have to understand what we can do with a computer device and what we can't. Okay, right. Break time. 10 minutes. 10. A little bit more even is okay today. There's not a lot to talk about, but we have data protection and we have to talk about the question. So we'll take a break and we'll come back. Yeah. Yeah, questions, definitely. Data protection and questions, 100%. I will discuss the questions, don't worry.
Why Ranga paper was discussed now before you joined?
Question and answers.
Question and answers, yes, my goodness, yes, the answers also very important.
Answers will be after the exam.
Okay, let's take 10 minutes, yeah? Okay, guys. All right, everyone. I assume everybody's back. So we move finally to talk about, although this is the last thing we talk about, it is probably one of the most important things that we need to talk about in today's day and age, right? Just in case my signal drops, let me know. I'm on my Wi-Fi, but it's raining, so I can switch to a hotspot. Just let me know if it starts to drop. Okay, guys. Okay. So data protection is a topic that has become a part of our conversation, not because data is new. Data is something that has always been there. Back in the day, you all would have remembered everything was done manually. But still data was collected, right? You go to a hospital, they collected data. You go to register for a school, they collected data. Data was always collected. Data was always processed. But why suddenly the need for an act? The need arises because of the acceleration of that data collection, and what can be done with that data has changed. See, back in the day when data was collected, the worst thing that could happen is what? You could get a newsletter or a leaflet on the post. No, that was the worst thing that can happen. No? The worst thing that could happen is you occasionally got this on the post newsletter about something, right? But now, what our data corresponds to is our entire life, because most of our life is spent online. Right? Do you know? Now you all have Google Maps on your phone, right?
Yeah.
Do you know whether you use Google Maps or not? You can go to your Google Maps and see where you exactly went in the last month. You can view everything.
Yes.
So that means if they are able to track that data, you don't think that data is somewhere stored in some server and Google is not using that data. So you are an individual who Google has more knowledge about than you probably know about yourself. Based on your searches, the places you visited, the things you do, the things you bought. Google has a very good understanding of who you are and what your data, what you are, what you're all about. So all because of this data collection, what this data has done, you have to understand the gravity of it. If you don't understand the gravity of it, you will never appreciate why it's important to protect your personal data. That's why I want to take a minute to explain to you why it's so important to understand data protection, why it's important for us to talk about data protection, right? Collection of data, how dangerous can it be? How important is it? Right? Now, you all know the basic things that happen no? When you do a search on Google or Facebook. After that, you get targeted advertisements from those companies on those things. That's the innocent version of what can happen with your data. Cambridge Analytica is the other extreme of what can happen. Data used to rig even American elections. Right? If you're not familiar about it, I am also not very familiar with it. You can check data Cambridge Analytica issue. You can have a look at it. Right? It's very important to understand. But think about it like this. People collect your personal data. That we can't stop. People in all facets of our life, people collect our personal data. But it depends. What this act is trying to do is to tell these people what they can do with that data. Number one, what data can they collect? Number two, what can they do with that data? That's what this act is trying to say. Think about how important it is. I don't know if I use this example when we talk about AI, right? Think about the possibility that you apply for a health insurance. Right? You apply for health insurance with a company, right? That also happens to own fast food chain. Fast food chain. I can think of a few in Sri Lanka that own fast food chains and health insurance companies and hospitals.
You are soft logic.
Right, there you go. Right? These companies own insurance companies, they own hospitals, they own fast food chains. Right. Now, when you apply for the insurance, right? What if the hospital is giving data that you have given to the hospital to that life insurance company? Your premium goes up. Why? Because it's sharing information with it. The fast food chain shares information with the life insurer saying he eats fast food 7 days a week, 365. Right? Sharing that information. Premium goes up. These data companies are talking to each other. And when they start sharing that data, right? It can have drastic impacts on you. Not only that your insurance premium will be higher, they may refuse to give you insurance altogether. They may say, no, you're too much of a risk, can't give you an insurance. But the thing is, do we give them permission to do this? Can they do this? These are all question marks that arise. Think about it. Think about all the places you give your data to. How many places did you give your data to today? Just jog your memory back and think how many places you gave your data to today. Anywhere? Anywhere that asks for your phone number, your email address, your name, your birthday. Anybody? Did anybody? You think? No?
3 places today.
3 places. Chaminda has given data to 3 places today. Right? 3 places. Data. Right? I went looking for preachers today with my wife. We have given data to 2 places. Right? Because they have asked us for our data to give us updates on what is available and all that. You've given our data. What does that mean? That data is now being used. That data is now being sold to the highest bidder. To this day, I get a message from a law school I have never been to here in Sri Lanka, asking to do a degree with them. Right? It's been 20 years since I passed out of law school. Right? But I, to date, get a newsletter from these guys. Because why? Either law college or the place that I did my degree has sold my personal data to these guys. Has sold my data saying, this is probably a guy who will be interested in law. This is what data is doing. So data, while it's amazing, it feels amazing to be able to Google anything and find the answer to anything. You also have to see the downside of it. The fact that the internet knows a little bit more about you than you yourself know about yourself, right? The internet knows more about you than your partner knows about you, right? Because everything you search for, right? I remember there was a time when I was, at that time I was still on Facebook. When we were close to getting married, me and my wife looked for wedding photographers on Facebook, right? Since then, I was getting advertisements for wedding photographers. Now, recently I just logged into Facebook. I don't use Facebook anymore, but I'm still getting advertisements for wedding photographers. Maybe they're thinking I'm going for round 2 or something, right?
Because Mr. Cabral said you are on demand. So maybe Facebook knows that as well,
Sir likes to make up a lot of things.
Yeah, but we told you what we heard,
But what I'm trying to say is this data is being shared. So think about it. Facebook as a company owns Instagram and WhatsApp. What you WhatsApp, what you Instagram will then translate to Facebook ads. Facebook will send you advertisements based on what that data is. So this data is very important. So therefore, the GDPR was passed in Europe. You've heard of the GDPR, the General Data Protection Regulation.
Right.
Very, very famous piece of legislation passed in Europe. The European Parliament passes it. Right? This kickstarts a movement around the world to pass data protection acts. And because Europe is such a big player, all the big data mining companies like Facebook, like Google, have had to comply with it. So therefore, when Sri Lanka passed the Personal Data Protection Act of 2022, Facebook didn't have to worry because they have already complied. They've already complied with that regulation. But the local companies now need to start complying. Local companies need to comply. The big data collectors are already compliant because they're GDPR compliant. Now, even companies in Sri Lanka that do business with Europe have to be GDPR compliant. So they have no problem. But local companies will have to now be compliant of the Data Protection Act by October 2024, if I'm not mistaken. If not, the penalties are severe. 10 million rupees per infringement, I think. Don't quote me on the number, but very, very high penalties. So what does this act say? The act tries to regulate the collection and the processing of data in Sri Lanka or partially in Sri Lanka. Section 2 says the act applies to the processing of personal data where the processing takes place at least partially in Sri Lanka or where the control or the processor of data is in Sri Lanka, offers goods and services in Sri Lanka, or monitors the behavior of data subjects in Sri Lanka. So it's a pretty wide net that it casts. It says that any of
signals are breaking.
Have to be compliant with the Data Protection Act. So every employee, sorry?
We are getting disturbance.
We did not get last 1 minute.
Hold on 1 second. I'm going to. Okay, give me 1 minute. I'll try and switch. Okay, hopefully that is better. Can you hear me now?
Yeah.
Okay. Hopefully that's better. Sorry, I told you, like I said, it's raining where I am, and that happens. Right. So, so the section casts a wide net on who it covers. Right. So now all these companies in Sri Lanka that collects your data, even employers who collect their data of their employees, have to be data protection compliant. So what does it do? What does it specifically do? And the most important section I want to talk about here is Section 7. Section 7 of the Act says that you have to make sure that the personal data that is processed is adequate, relevant, proportionate to the extent that it's necessary for the purpose for which the information is collected. I'll say that again. Personal data that is processed is adequate, relevant, proportionate to the extent that is necessary for the purpose for which the information is collected. So it says that you can only process personal data to the extent that it is necessary, adequate, proportionate, and relevant. You can't go beyond what is necessary. You can only process personal data for the purposes that is necessary. Right? Proportionate. Proportionate means you cannot go overboard. You can't collect my data and use it for all kinds of things that are unnecessary. You can do it for certain things. Only specific things that you can use my data for. For the purposes you have collected my data, you can use my data. So it also puts into question, can you just collect any data you want also? Or is it limited as to what data you can collect?
There is a boundary placed here, in this.
The Act doesn't necessarily place a boundary on what can be collected because it says what the input for the purposes for which the information is collected. It doesn't say what information can be collected.
Yeah, adequately relevant.
Yeah, but you can only process it. So, but you could make the argument that this data now can only be collected for necessary things. So, for example, think about it. If you're buying fast food, do those guys need your phone number, your email address to serve you fast food? Do they need to have that data?
Their purpose may be to give you the promotion, the information about their product and all those things. Not to really collect the data, what you're going to eat and all those things.
Correct. Yeah. So no. So the phone number, when they ask for a phone number, what their purpose is to use it for advertising purposes, marketing purpose. So that means this Act says now they can't sell it to somebody else.
Correct.
If they are collecting it only for advertising purpose to send me promotional material, they can't send it to someone else. But I should have the good sense to also ask, when somebody asks me for my phone number now, I always ask, why do you need it? Right? And often I say, no, I don't want to give the phone number. If you don't want to sell me the product, right? Because I'm refusing to give you my phone number, then forget about it. I'll go to some other shop. And often when you say, no, I don't want to give it, they back off. But the thing is this, the Act doesn't prevent them from collecting data which you voluntarily give. Provided you voluntarily give the data, there is nothing that is wrong with as far as the Act is concerned. So we as consumers, as data subjects, as far as the Act is concerned, data subjects, we have to be very conscious of what we are giving our data for. Understand what. So I remember I went to a shop recently and they asked for the phone number. I said, why do you need my number? What is the purpose for which you're collecting it? And they said, well, we have a reward scheme. So you get, 1 point for every 100 rupees you spend or something. So for that purpose. I said, fine, okay. I gave my phone. That's okay, legitimate. I understand. Then I went to another shop. They said, sir, we let you know of all the promotions that we run. I said, no, thank you. I don't need that. We as data subjects need to start being more conscious about what data we are giving out. We can't then later complain we don't have privacy. Yeah, that's fine, Roshani. You can be excused. You can talk to one of the guys about the questions that are going to be discussed. We'll be discussing the questions. Yeah. Okay. All the very best. Right, I won't see you guys again. Yeah, all the best to the exam for the exam, and hopefully I get to meet you guys in person one day, right? And I get to see your art. Okay. All right. So so section 7 places a restriction on what the data can be used for. But remember, the act can only do so much. It can't prevent you from consenting to give your data. So you have to be conscious about what data you want to give. So now something I always recommend to my students are young children, right? I mostly teach 20-year-olds who are very fast to technology. They don't think about what they're doing. I always tell them, have a separate email account which you use to sign in for all these websites. That's what I do. Okay, Roshani, you'll be rejoining. Fine, great. Okay. Have another email. That's what I do. I have an email account simply for logging in purposes. That doesn't have any of my personal data. It doesn't have my address book. It doesn't have my contacts. It doesn't have any other data on mine. It is just an email account that I maintain for login purposes. Because every time you log into a software, get into a software, what does it ask you to do? Log in. Give your data. So then what they ask you, we want access to your contacts, your phone, your photographs, your this, that, and the other. But this account doesn't have any of those things. So I give access to that. These are good habits for you guys also to now start implementing in the digital age. Because you have to understand, like in the last week, I would have downloaded about 5 new apps. I'm an enthusiast. I like to download, check out new things, and then delete them when I don't like them, right? But if I start giving my data to every one of these, what's the problem? That's the problem. So this is also why you have seen now a change in the attitude of companies like Facebook and Google. They are privacy centric because they have now compliant with the GDPR. Now they are asking for your permission before they use your contacts, your phone number, your phone photos, your geographic location. You are given access, full control of it is given. Back in the day, that was not there. Now you can go to Facebook and completely delete your data. Your entire profile, your entire data can be deleted. Back in the day, you couldn't do it. Back in the day, even if you deleted your profile, a profile for Mahela Liyanage was still there. It's called a ghost profile. Ghost profiles were there. But now you can completely erase because GDPR lets you do that. But you have to understand Section 7 only places a limitation on data processors using the data that they have collected for purposes other than for what they have collected. So you have to be smart about it. You have to do half of the work. Start being conscious about your data, what you share with people, right? What you share with companies. Always ask the question: do they need my phone number, or do they need my age, or do they need my religion, right? When I log into a software, no, they don't need that. A fast food chain doesn't need to know what my religious beliefs are. But or for that matter, my marital status. But my employer might need to know my marital status. Why? Because the insurance will cover my spouse also. So for that purpose, he needs to know. So there are certain instances where you need to give data. So we have to find a happy medium here. But Section 7, essentially important section that you have to understand. Data can only be processed for proportionate or necessary functions. Necessary for the purpose for which the data is collected. You can't do it beyond that. You can't go beyond that. You collected the data for a reason. That is the only thing you can use that data for, right? Of course, big data companies will find a loophole, right? In all of this, they will spend millions of dollars on lawyers, and they'll find a loophole. If somebody pays me a buttload of money, I will also find a loophole in this law, right? But they will find a loophole. But what I'm saying is, if we are conscious about what data we put out, right? You've heard about those stories where somebody uploads a Facebook picture right, in Sri Lanka or somewhere, and in another part of the world, that picture appears on a bus. A hoarding on a bus had this family's picture. Somebody downloaded and used it. So this is problems for personal data. Personal data is being used. Now it's gone to another level with face recognitions and all that. Right now, if you look at, do you use Google Photos? Do you guys use Google Photos for your photo keeping, or do you all use Android or iPhone?
I used to a little extent to store because it gives you I think 25 GB or something storage space, Google Photos.
Yeah. So you all are iPhone users or Android users? In Oman, what is it most about? Mostly iPhone, is it?
Yeah.
In my case, I'm iPhone, yeah.
Okay, so that means you all use Apple Photos mostly.
Yeah. Apple storage.
Yes. Apple just introduced, if you saw their new software update that came out 3 days ago or 2 days ago, if they also introduced the same software that Google uses, which is face recognition. So it categorizes the faces it looks through your photos, analyzes the photo, and now identifies groups people together, groups the places together, and gives all of that in a convenient carousel. Right? So all of that is data being collected. They're looking at your picture and learning things about you. Google knows where I was 1 year ago, 2 years ago, 3 years ago, 10 years ago. It constantly reminds me on my photos. Now, I think a similar function is existent on Facebook. So yeah, I'm very out of date with Facebook. I don't use it, but Facebook also has something called memories or something like that.
Yeah. Also, like if you like some place or something, they also say your 3 friends had been into this place before, like that.
There you go. Yeah. So this is the problem. Now, this is a big problem now. Now companies like TikTok are even more dangerous. At least Facebook and Google are compliant to GDPR and they are very much regulated. TikTok comes from China. Regulation is very limited. So there's another question mark that arises there. But of course, they claim that they are very compliant. They are clean. Right? But we don't know. These are interesting things. So I was working once with a software developer, and he was saying that they can monitor the movement of your mouse on your screen. Now, if you're on their website and you hover around the buy now or the add to cart area, but you don't click it, they know. They know that you hovered around that button but didn't press. Your mouse, you can move your mouse around now. Now you move your mouse. Sometimes even I have this problem with regard to online shopping, constantly shopping online, buying all unnecessary gadgets, right? Now I go to my cart and I go to click buy now, but then I stop. They monitor that. They know what percentage of people go to the buy now button but don't click it. So then they use that data to entice you to press it, give you a promotional code, a promo code. Right? They don't give you promo codes because they love you, no? So a promo code is given to you because they know you are one of those people who's less likely to press I accept, buy now. So think about the level of lack of privacy we have in our lives. If they can do that, right? So it's mind-blowing. Again, I am not an expert on this subject, right? I know Dr. Kabra likes to say I'm an expert. I'm not. These are new things. I'm also developing and learning these things as I go along, right? But what I can say is that, look, it's very important that we understand what kind of data we are putting out into the world and protecting ourselves, okay? So anyway, Section 7, very important to understand. Then Section 8 says, you have to ensure that the collector of the data must ensure that the data is kept accurate and up to date. If they collect data of yours, they have to keep it accurate and up to date. So your employer who collects your details when you join the company has to update it regularly. If you change your address, it has to update. If you had another child that was born, it has to be updated. They have to keep it updated. They can't have outdated data about you. The data must be kept updated and accurate. Section 9 says that the identification of the data for the period that the data must be necessary only. You can only hold on to that data about me for the period that it's necessary. After that, you have to anonymize it. See, while I'm in the employment of my company, they can have data about Mahel Liyanage. Or while I'm shopping on Amazon, they can have data about Mahel Liyanage. But if Mahel Liyanage shuts down the Amazon account, then they can't have data about Mahel Liyanage. They can have they can anonymize my data and have it. That is, oh, a person of this age, of this ethnicity, of this color, these likes, these are the likes of that kind of person. That kind of anonymized data they can have, but they cannot have personal data about. You understand what I'm saying here? They cannot maintain data like that, right? Then section 10 says the data must be kept confidential. They have to keep it confidential. There cannot be data leaks. If there are data leaks, now you have to inform it to the Data Protection Authority, and there will be punishments. Every company has to have a data protection officer, and they have to correspond to the Data Protection Authority saying, look, there has been a leak. Here is the data that was leaked. Right? Then important sections, section 13, 14, 15, 16, very important. After section 7, very important sections come up in 13, 14, 15, 16. 13 says, data subject can ask the controller for access to their data. I can at any moment ask you, can I see what data you have on? Has anybody tried that? You have the Google app on your phone, right? Go to your Google app, go to personal information, and see all the data Google has on you. They tell you, they are supposed to disclose that data now. You can at any moment ask access for your data and see what kind of data they have collected on you. You have the ability to do that, right? If on your smart device, you have a Google app, click on it, go to settings and find that place. You can have access to your data. Anybody can have, you can go to your employer and say, give me all the data you have on me. They have to disclose it. Section 13. Section 14, you can ask the data controller to stop processing your data. You can say, stop it. Don't process my data anymore. You have full control. I may have shared my data with you, but I want you to stop. I don't want you to process that data anymore. Section 15, you can ask them to rectify the data. If the data is incorrect, you can say, look, this data is not correct. Please correct it. And section 16, probably one of the most important sections, the right to disappear. You can ask the data controller to delete all your data. Every piece of data they have on you, you can ask them to delete. So if you want, you can go and become anonymous. The right to disappear, we call it. You have the right to disappear. You follow what I'm saying? Right?
Yeah.
Then, of course, there are other requirements. Every company or group of companies will have to have a data protection officer, section 20, right? Then we know that there will be a data protection officer appointed, right? Then I'll come to section 27, which is an important section again. Solicited messengers. You know, you'll get advertising messages.
Yep.
You're constantly get, yeah. This says how that kind of message can be given.
Solicited messages.
You can't send unsolicited messages anymore. Right? Number one, that means to get these messages, promotional messages or anything, I have to have consent. So my argument is technically when Taco Bell asks me for my phone number and I give it, they still can't send me messages because I have not consented to receiving messages. But of course, Taco Bell will make the argue, you gave the number, that is consent. That is what they will say. So these are things that will have to be tested in court. We'll have to see. Who knows? I might go and file a case. I hate these messages, right? But these are things that can be tested in court. But right now, the law says that you can only receive messages if you have agreed, solicited, you have agreed to receiving these messages. So that is why now in most websites and softwares, you have a little box to tick. I accept to receive newsletters and promotional material. You click that button, then you are consenting. It will be automatically clicked. They'll be smart. You can unclick it if you want to, but they will have it clicked anyways. But if you click I accept after with that, then you have consented to receiving the message. Number two, there must be an opt-out option given. That means you have to be given an option to unsubscribe. That's why when you get this promotional material, at the bottom, there's an unsubscribe button. Right? And you must identify who's sending these messages. You have to say who you are when you are sending these messages. So very important, right? Very important things, because you have control to some extent of your data. But you have to understand, when you understand this act, and these are the major ones. Section 28 says there will be a data protection authority appointed, right? But Section 32 says that the data protection authority, once appointed, can hear complaints about data protection. Like the Consumer Affairs can hear complaints about consumer affairs, Labor Tribunal can hear labor cases, Data Protection Authority can hear cases about data complaints, right? So, but what you have to understand here is you have been given some control, but if you keep clicking I accept and giving all your data, when you click I accept to any of these terms and conditions, what are you doing? You're consenting. When you click I accept, you are consenting to have them having your data and doing anything they want with your data. So as long as you do that, there is not much that can be done. The act can't help you. You have to start being conscious about what data you're giving. Why are you giving it? Do I need to give this data? Right? Because you don't know. The world that we will live in the next 10 years will be very different. And we don't know what that world will look like and how your data will be used to hijack you. Right now, you think them collecting your data is not so bad because all that happens is you get promotional material. But what if this data is used for dangerous things, for surreptitious things, to disturb the privacy of you and your family, to disrupt the protection of your private life, your family members' life, right? What if that is the case? So we have to start being conscious about how we use our data, how we give our data, because if we are not conscious about how we give our data, no amount of acts can protect us. But the act is there. Now it's there. It's there and will become operational. Now we gave the companies 2 years to become compliant. At the end of this year, it will become operational. And anybody who is not compliant will be committing an offense for 10 million rupees every infringement. And you will see in early 2025, there'll be a couple of cases against some big companies, 2 or 3 big companies, and everybody else will get in line after that. Right? But right now, the Sri Lankan market has gotten used to just abusing this data and using this data. But because the big players are now somewhat regulated, right? But still, the big players have found a loophole, which is consent. If you give consent, it's in contract law. So we talked about in the consent. If the parties consent, there's nothing that can happen. The same thing. Okay. So that is my take on the Data Protection Act. Any thoughts on it? Any concerns that you have? Any comments? Anything you'd like to discuss?
It's pretty clear. Important sections 7, 8, 9, 10, 13, 14, 15, 16. So you basically briefed, what is.
Yeah.
I'm sure there are other sections, but I think you focus mainly on the.
I only focus on the really important ones. I didn't go into everything because that's unnecessary. But yeah. Okay. So we are okay.
Sorry. If it is a case where we magistrate court or high court or anywhere they are defined that term?
Data Protection Act, where the cases are going to be heard. That's a very good question, Kamal. Unfortunately, I don't have the answer for it. I have to check. I don't know.
Okay.
Right?
No, you said previous one, the high court, that's why I asked.
That's a very, very good question. It's a question I should probably have an answer to as a lecturer on data protection, but I don't, unfortunately. Let me check on that and revert back to you if I can, right? I'm not 100% sure on it. I don't want to lie to you and say something which is not true. Because it's not tested yet. It's not come into effect yet. So that's the problem.
Yeah, it's not effective. Yeah.
Okay. Anything else? Any other thoughts? Any concerns? Right. Then we get into the paper. What are you going to get questioned on? Right. So everybody's aware of group assignments are done. I have marked you guys. I will send the marks to PIM. Individual assignment will be submitted by the 21st. I think you'll have a deadline extension. So 21st you will upload and I will have a look at that. So what are we going to question you on for the exam? It's going to be 5 questions. But please make sure that I know it's a take-home assignment for you, that you write it on your own. Whatever assistance you get from ChatGPT or whatever is fine, but write it on your own, because if not, it's difficult for us to give a pass mark. Okay, that's one key piece of advice I tell anyone who is writing exams on their own, right? Okay, or writing or exams online, right? One question we will question you is on contracts. We will give you a question on contracts, specifically speaking on offer and acceptance. Remember offer and acceptance? What amounts to an offer?
Correct.
What amounts to acceptance? Right? When is there a valid offer? When is it not a valid offer? Remember, we talked about invitations to treat versus offers. What is a valid offer? What is not a valid offer? What are the requirements of an offer? If you look at the note, I would have talked about 3 or 4 requirements of an offer, right? Have a look at those. Those are important, right? Similarly, we talked about several requirements in an acceptance. What are the requirements for acceptance? Right? Have a look at those. So, in addition to all of that, dress it up with some case law and all that. Do some research. Don't limit yourself to the cases that I've given you in the note. Right? Look at Vikram Veerasuriya's book. Find the cases. There are lots of cases online. You can do some research. Find it. So the highlight should be on offer and acceptance here. Okay. Is that clear? Any questions on that?
Very clear.
Right. Another area we will question you is on D-Links. We will give you a question on D-Links or thoughts.
Right.
Thoughts, we will give you a question. This will be a case study. It will be a case study around the case of Donahue versus Stevenson. Remember, I spent a lot of time yesterday talking about that famous judgment. Right? Donahue versus Stevenson, you will have to familiarize yourself with the facts of that judgment. What is the major legal principle that was discussed in that judgment? What is the test that was developed in that judgment? All of that you will have to know. Because the question will be around the facts and principles of Donahue versus Stevenson. Remember, if you remember Donahue versus Stevenson, what did it focus on? What is the principle that it focused on? Duty. More than breach and causation, Rangajeevi, it focused on duty. So the principle it focused on was duty. Remember the neighbor principle? We talked about the neighbor principle. Yeah. What is the neighbor principle? When is there a duty formed? Yeah. What is the test for a duty? Remember what we talked about, the requirements for a duty? For there to be a duty, what are the requirements? That will be the area around which we will give you a question. Look, we are narrowing it down. It's very little that you have to really go in prepared for the exam. Like Dr. Cabral doesn't believe in giving very difficult papers, right? His philosophy is if you learn something, that's good enough. So that's why we're giving you the questions, the areas also so clearly so that you can prep and come. But the fact that you know this means everybody will write the basics, huh? So your paper has to stand out. If you want to get your, first classes and all that, want to get good marks, stand out. With this model of us telling you what the papers and the exam questions are going to be, everybody will pass because everybody knows this, right? But if you want to stand out, if you want to get good marks, you have to do some work, right? Half a page on this is not going to work, huh? Third area we're going to question you is on IP law, intellectual property law, IP Act. Yeah. The IP Act, specifically patents. We will talk about patents. The question will be around patents, patents, whatever you want. Right? What is a patent? How are patents protected? What is the requirements that you need to satisfy in order to get a patent? Basically, sections 62, 63, 64, 65 of the Act needs to be familiarized with. Those are the main sections. I think 62, 63, 64, 65, 66. Those sections will have to be familiarized. What is a patent? When will you be given a patent? What are the requirements to get a patent? Those have to be very clearly understood. Around that, we will give you a question. Okay? Then we'll give you a question on companies. Companies Act of 2007 will give you a question. And the question will be around board meetings, the types of meetings that are discussed under the Act. So I would have talked about what are the types of board meetings, right, that you can have. Shareholder meetings, EGMs, AGMs, right? The different sections, section 133, 4, those sections will have to be familiarized. Then resolutions. Ordinary resolutions, special resolutions, circular resolutions. You'll have to familiarize yourself with all of that. We will give you a question around that. If you listen to what Sir said, you know the answer to these questions. These are not difficult.
Yeah, even things like the patent and all, Mr. Cabral went to extraordinary length to explaining them. We were actually even really appreciative and didn't expect that he bring all that in his bag. Small pieces of cartoons and did the best that I think anybody can do.
So around resolutions, you'll have to know section 91, 92, 93. I can't remember, but around that, board resolutions and meetings. Okay, you'll have to familiarize yourself with that. And then finally, question number 5 will be around data protection, the Data Protection Act. More specifically, the rights of a data subject. If you remember, we just talked about.
Correct.
The rights of a data subject. That will be mostly section 13, 14, 15, 16. What are your rights as a data subject? The right to access your data, rectify your data, stop processing your data, erase your data. Those bits you'll have to familiarize yourself. We'll be giving a question around those.
And right to disappear.
Right to disappear, section 16, yes. So those are going to be your questions. Rangaji, I hope I did a good job giving the question and the answers.
Compiling everything and put it into the answer paper. The question.
And you did a good job by identifying the person who's most sensitive for the questions. Sanjeeva looks like there is some data sharing. Huh?
But so I'm happy to answer any questions that you all have related to the question paper, related to the topics we have covered. Anything I can cover, anything I can answer, I will try and answer. Anything with regard to the paper, any questions, clarifications that you want. Look, I'm not expecting answers that are 4 or 5 pages long. Huh? You don't have to write that much. If you answer the basics, that's enough. But that also doesn't mean half a page is good enough. You have to write a substantial bit of material. But again, you use your best judgment. If you discuss everything, my recommendation is use examples, use cases, use scenarios. It doesn't have to be cases. Huh? It can be scenarios. Examples. Those can be good ways of conveying your issue. Right? Use those because that stands out. Because if not, what happens, you know what? Every paper, look, I'll be very honest with you. I do most of the marking of these papers, and I have to mark approximately in this next coming month, I have to mark with your papers, 300 papers.
Oh.
Right? 300, right? So unless your paper is going to stand out, it's going to get lost in the horde of other papers. There'll be a few papers that I will remember. I will, kind of think, oh my God, this is amazing. This guy really understands what we're talking about, right? Few papers will have that. So your objective should be that, to be able to write a paper that attracts the attention, because you have to understand, we are also human beings, right? When I read these things, if I'm bored, I'm bored. There's nothing can be done about it, right? Because everybody will write the same things. So it's about how you present it. So that's very important that you spend some time thinking about it, formulating your answer. So you have enough time to prep for this. These are not difficult questions, right? Right? So Dr. Cabral always says, remember that the examiner is also a human, right? And because they are human, they will also be attracted to the answers that have explanations, cases, flowery language. We like it. But of course, a question that just gives you the sections and finishes it off will be middle of the road. So you want to be in the top tier. We are not stingy about giving marks, right? We give marks liberally, but if you want to be in that top, 75 marks plus in your paper, you have to do well. If not, you get average marks. Okay. You follow what I'm saying? Okay. Any questions on the paper? Any thoughts?
Any formats? No, nothing formats. So we have to...
No formats. Just answer the question. That's all. Yeah. Look, one mistake I see students making is they write the entire subject. Like if it's contract law and offer and acceptance, they talk about consideration, illegality, privity, capacity, everything also. I don't want to know all of that. That means you're not confident with what you're writing. You're trying to cover your bases by giving all the points. Don't do that. Know what the question is on and answer that part. That's enough. Yeah. So no format as such. Yeah. Anything else? I'm happy to talk about anything. I mean, look, whatever we talked about is very relatable to you guys. Anything you all have questions or queries on, I'm happy to answer.
Like always, what I have to say is, I generally not good at holding questions, so I fire at you whenever I get it, and you very kindly accommodate those as well, and I really appreciate.
Absolutely. Also, Mahesh, I know you have dropped me an email, Mahesh. I've not forgotten it. It's just been in the pile of emails in my inbox. I will get to it. I've not forgotten it. I'll reply to it. Okay. I saw Mahesh had dropped me an email about a week ago, and I still haven't replied. Yeah. Anything else?
Mahesh is also in Colombo. Looks like he got lost somewhere. Oh yeah, he just
no. He's there. He's there. He's probably at a place where he can't unmute himself.
Maybe. Maybe signal.
So very, very precarious. You can't unmute yourself sometimes. No?
Yeah. Nandana, Saturday night, 8 o'clock in Colombo.
Yeah. So yeah. Anything else? Any other questions, guys?
Yeah, in the Prerna, today is the group assignment due date. So we don't need to upload any slides, right? Because we already done our presentation. Do we need to upload our presentation into group assignment?
You can upload it if you want to, Shahid, but I've given you marks. Don't worry. It's done. Group assignment is done.
Oh, okay.
I've already given the marks. You all have all done very well in that. Don't worry.
Oh, okay.
Group assignment, you can all three groups can say tick, done. Don't worry. Done. You'll have passed that part. Now the other two parts only. Only other 80% that you have to pass. Very few fail this module. We don't like to fail people. Very few fail it. But I have failed a few people. People who write like one paragraph and an answer, I have failed. Right? That means you have not paid any attention. Right? You have to pay attention because look, Dr. Kabra says this when generally I leave the paper discussion to him. I don't do it. But he always says, look, we make a lot of effort to deliver these lectures and like spend our time like to explain everything. It's insulting if you write like one paragraph, right? It's insulting to us. That means you have not understood anything. You're not paid attention, right? But you guys, I've no doubt that you'll be very, active on the group also, even though it's an online session. It's been fun to teach. So I'm sure this will not be a problem. So very few fail it, but some do.
So okay. This all we need to focus on, the act on Sri Lankan act only, no? And the UK.
Yeah. Your focus is on the Sri Lankan acts. But of course, Shahir, you can use case law from other countries. Most of the cases that we talked about are international cases. You can talk about cases. Yeah.
So Sri Lanka have very limited cases.
Yeah, I mean,
Yes.
for these areas, for business law, we mostly rely on English cases, Kamal. Like for land and all that, we have when we were in law college, all we learned were cases on land, right? Sri Lankans love to go to court on land issues, no? And contract and all that have Sri Lankan cases, Kamal. Don't get me wrong. There's a lot of cases. If you go through Vikram Veerasuriya's book, you'll find a lot. But the thing is, all those Sri Lankan cases are based on an English judgment.
Yeah.
So I've just discussed the English judgment straight away with you.
Yeah. It's very
That's what I'm
familiar.
saying.
Some are very familiar. Like
Yeah, like Balfour versus Balfour that talks about domestic agreements. There are 10 Sri Lankan cases on it, but they are all reliant on Balfour versus Balfour. So why wouldn't I just discuss the original case? So that's what I've done.
£30 payment to wife in England, correct?
Yes,
Balfour.
yeah, correct. Yeah. Yeah, Rangaji, what's up?
Regarding these total questions, you said that
Yeah.
it will be a case study, right? I mean, you will give the case and accordingly we have to answer the question. Then you will
So you know the case now, no? You know the case, so I'm expecting you to know the facts of the case also. That's what I mean in case study. What I mean by a case study is that I'm expecting you to know the facts of that case.
facts, judgment, and effect like that. All three.
Yes, facts, judgment, not so much, Kamal, but what is the principle that came from the judgment is what I kind of want to know. Okay? So the principle is duty, no? That he established a duty. So that principle has to be explained. Yeah.
Duty of care.
Yeah, absolutely.
Right.
Good. Anything else? Any other questions?
No, there is some question in our group.
Yes, tell me.
Because nowadays there are so many matches, triggered matches going. No, they are like there's some betting like that. Okay,
Yeah.
it is friendly. Somebody told that today they are going to maybe win this one team.
Yeah.
He said, how much you bet? Like that.
Yeah.
Somebody's upper, okay, 50,000, 25,000 like that.
Yeah.
But unfortunately, that he won that who opposed that one. He won the he won that one. Now he has money. He said, other players only know there's no contract.
So yeah, offer and acceptance. Yeah.
Yeah, offer acceptance.
Very good. Very
But
good.
really, it is but he said, okay, he said, propose. He asked how much, but other below said it is 25,000. But only after that there is no silence. Like, but finally.
So how much is not an offer, no? So the 25,000 would be the offer. So somebody has to accept, I would think.
Yeah, that's right. He has how much bet like that, how much bet like. But after that, there is no silence that there's no contract.
And we know silence is an amount to acceptance too.
Sometimes.
No, we know. It's a rule. Silence is not acceptance. You'll have to study that up for the exam, huh? Silence is not acceptance.
Unless it is
particularly
in the condition phase.
Correct. Unless in the no, even then, you remember we talked about a case where somebody wrote a letter saying, if I don't hear back from you, I'll consider that accepted. We said the law said no, that's not accepted.
Then you need to
silence isn't. Yeah, you have to reply. Express reply must be done. Yeah, express acceptance must be done. Yes.
Acceptance should be unconditional.
Unconditional and express. It must be clearly expressed. It cannot be silence.
Yeah.
Good. Anything else?
Thank you very much.
If nothing else, we can wrap this up. Yeah. Okay, guys. So I assume everyone has my contact details. If you have my email address and you have my phone number. So if you do have any questions, I think in the resource thing, you should have my details.
Already
right?
mentioned, Mahela. It's already there.
Yeah. So if you do have any questions, just get in touch. And if you guys are in Colombo and want to grab a coffee, let me know. We can always meet up. Right. So yes, hopefully I'll run into you guys either in Oman or in Sri Lanka somewhere. Hopefully somewhere in the world we'll run into each other. Right. All the best for the exams. Yeah. Don't worry about the exams. The exams will be fine. Don't worry. Yeah. It was fun teaching this batch. So all the best.
Thank you very much, and we had a wonderful and lovely session so far. This is the best, I would say. I mean, yes, Professor Ajanta also. We had a good sessions. And thank you very much. It was lovely. I mean,
No.
usually specifically when I was in Sri Lanka, I will never come for the session because we'll not get the time. But somehow I managed these two.
I'm glad you did. I'm glad you did.
So it was wonderful, and thank you very much for the knowledge that you share with us, and specifically in the case and practical scenarios as well. And of course, love to sit and have coffee. If I get a chance, I will.
Yeah, get in touch with me, Rangaju. If you're free, we can meet up for a coffee. Yes, let me know. And anytime you guys have any questions, legal related, anything that I can answer, just drop me a message or an email or whatever. Text me. I'm generally active on WhatsApp or email, so just drop it to me and then I can answer it. It can be related to this. It can be later. It might be 10 years from now when you have a legal question, but drop it to me and I'm happy to answer. If I know the answer, I will more than willingly answer the question. Right?
Thank you very much.
Learning doesn't stop here. Don't forget that. Right? That's very important.
Correct,
right?
very
You
correct.
just started learning law. Don't forget it.
In future also,
just keep...
you going to conduct any module for us?
No, I don't think so. This is it. I only do business law.
Only you.
My knowledge is very limited. Only law. My knowledge is only law. Yeah. Okay, guys. If there's nothing else, let's wrap this up. Okay. Good night.